Good day, everyone. I'm thrilled to be here today to present a new draft regulation on labeling in advertising, Regulation 3337. So R3337. This, of course, is a crucial topic affecting everyone from food handling organizations to also consumers. And I'm excited to share the latest development in this field as per the draft regulation. As you all know, food labeling is an essential part of our daily lives, and it plays a critical role in ensuring that we make informed choices about the food we consume. However, with the ever-increasing complexity of food products and growing concerns about food safety by consumers, ensuring that information on food label is accurate and comprehensive has become even more challenging. So in this webinar, we are hoping that with the information that we're going to share, you are going to see exactly what is it that you need to pay attention to, submit your comments, or prepare your organization to comply with. Of course, as we said, this is a new draft regulation. It is not yet promulgated. It's still in a draft form, so you still have an opportunity to submit comments. And of course, the day for comments has been extended to the 21st of September 2023. So you must ensure that by the time the comments are closed, you have submitted whatever comments that you have, and also that has been taken into account when before they publish a final regulation. So you must make sure that you also look at your business, the type of product that you handle, and look into those products and see if you were to comply with the regulation at their current state, how is it going to affect you? Of course, as a food safety expert, I've seen firsthand the devastating effects of inadequate food labeling. So this regulation is significant in terms of addressing some of the concerns to ensure that consumers have access to accurate and comprehensive information about the food that they consume, which is critical for their health and, of course, their well-being. Let me then introduce myself. My name is Mtokozi Sinkosi, and I've been in the food safety industry as a consultant since 2014. So I've consulted, audited, trained in all aspects of food safety. So the different certification schemes, could be FSSC 22,000, the different BRCGS standards, including non-GFSI recognized schemes. So I've done a lot of those, and I've been involved also in the regulatory compliance, either the regulation R638, R146, interpreting that, and also be involved as a stakeholder, and of course input whenever my input is sought. So my background is in agriculture. So I studied as my first qualification, food science and agricultural chemistry. So that was my undergrad qualification. And then I went on to study further in public health, in business, and of course, also food science. So that is the short background that I have. And of course, auditing on the different certification schemes. I represent a company called ASC Consultants, which is a renowned consultancy that focuses on consulting on food safety management systems, your BRCGS, your FSSC 22000, IFS, Global Gap, SQF. So we do all that. We train on those certification schemes and standards. We audit them, especially the second party audits, where companies appoint us to become their internal auditors, either to ensure that their system is matured, or also to just prepare them for certification. And of course, some of us have consulted and audited for different certification bodies in the past, although most now we are focused on servicing our clients, either consulting, system maintenance, as well as training. We also have food science consulting services where we consult in the fields of food science, either product development, shelf life studies, microbiological result interpretation, or looking at foodborne illnesses that could have spread and occurred, and that also branch into our public health consulting services. We, of course, train and also audit in all these standards. Also, public health, we do conduct workshops in terms of the topics around public health and also do some auditing thereof for food facilities that require our services. So we are going to then discuss food labeling and advertising regulations, but it is important to firstly look at the importance of food labeling regulations. Why is it necessary for governments to implement or these labeling and advertising regulations? Of course, there are many opinions when it comes to labeling and advertising regulations, but our opinion is that it is important to have these regulations since they ensure that accurate and comprehensive information is provided to consumers about the product. This could include ingredients, nutritional contents, allergens, and any other potential health risk, therefore allowing consumers to make informed choices based on their dietary needs, preferences, and potential harmful things that could be present in the product, such as allergens for those who are allergic to certain substances. Health and safety reasons as well. Regulations help to ensure that food and beverages meet specific safety standards. This includes proper handling, storage, and processing practices, which would include your the good manufacturing practices, traceability, and all those things. Clear labeling can also help consumers identify potential health risks, such as allergens or additives that may be harmful to certain individuals, because some individuals are, of course, sensitive to some ingredients or to some products. But most importantly, it prevents deceptive practices. Advertising regulations prevent misleading or false claims about the product's quality, benefits, or ingredients. So that's where we say that it prevents misinformation, misrepresentation, mislabeling, and also incomplete information on the products. So this then helps, this protects consumers from being deceived by exaggerated or unsubstantiated claims, ensuring that they are not misled into purchasing products that do not meet their expectations. Of course, fair competition. The regulations create a level playing field for businesses by setting standards for labeling and advertising practices. This prevents unfair competition by ensuring that all products adhere to the same rules, preventing misleading claims that could give certain brands an unfair advantage. And for public health aspects, the labeling regulation can contribute to public health initiatives by promoting healthier choices, which we see a lot in this regulation, draft regulation R3337. For example, the regulations may require the inclusion of information on sugar, sodium, salt, or fat content, helping consumers make informed decisions about their diet and reducing the risk of chronic diseases such as your diabetes, for example. So all in all, labeling and advertising regulations are, of course, essential in protecting consumers by providing accurate information, ensuring product safety, preventing deceptive practices, promoting fair competition, and contributing to public health initiatives. Currently, we do have a labeling and advertising regulation in South Africa, which is the Labeling and Advertising Regulation R146 that was published by the Minister of Health at the time on 1 March 2010 in terms of the Foodstuff, Cosmetic and Disinfectant Act 54 of 1972. The regulation only came into effect on 1 March 2012 after granting a grace period of 2 years to the food industry to comply with the regulation requirements, since the new requirements had logistical and operational impact on the food industry. So it was a big thing at the time when this new regulation was promulgated. Compliance with the requirements of this regulation is enforced by EHPs, environmental health practitioners, and of course, non-compliance leads to the issuance of non-compliance notices to businesses. And if you still do not comply as a food business, then legal steps may be taken and of course, prosecution. In 2014, the Department of Health also proposed further significant amendments to the regulation published as Regulation 429, but it was never really promulgated. But maybe before we get to it, let's look at the history or the timeline on the labeling and advertising regulations. Let's start with what happened before 1993. There were basic regulations under the Foodstuffs, Cosmetics and Disinfectant Act that were just very basic in their nature. There was a section that was dedicated just to the labeling and advertising regulation. But it's not until 1993 where the regulation 2034 was then published, and it came into effect on the 1st of May 1995. And there was a lot of excitement around these new regulations since it introduced some of the sweeping changes that have found itself throughout in the updates of those regulations, like health claims, for example. But of course, then regulation R146, which is in fact the most comprehensive regulation that we have to date, looking at labeling and advertising, foodstuff, cosmetics, and disinfectants. It was published, of course, in 2010, and it came into effect in 2012. It had very specific limitations on health claims. And then in 2014, there was a draft regulation 429 that covered a lot of gaps in regulation R146, but it was never promulgated. It created a lot of controversy, this new regulation, and a lot of submissions were made to speak to the changes that were being introduced by the Department of Health. The specific things that were topical at the time was because it prohibited certain trademarks, and it created a lot of then controversy, especially the specific labels that were supposed to go to the product, onto the product. But of course, it was never then finalized. And then, boom, this year we had then the draft regulation that went through a different stages. So initially it was regulation 2986 in January, and then we had regulation 287. Importantly, it's important to note that regulation 2986 was very similar to regulation 429, and then regulation 3287 had some changes. It was a second version, and that was published on the 14th of April 2023 with those changes. And then regulation 3320 was published again on the 21st of April 2023. And there were problems, the minister's signature and all that. So then they published on the same day with and then it was renamed. Of course, there was a problem with the regulation name. So that regulation, if I remember correctly, it was the name of the regulation. I think the one prior to that was unsigned by the minister. And then the same day, on April 21st, then regulation 337, which was then corrected, was then published. And this is where we are today. So with the new regulation in the pipeline, you should expect a lot of things that have been introduced. And of course, we are going to go through it as much as we can, looking at the specific sections that we think are of interest to you. The thing to note is that the current draft in question has a total of 249 pages compared to regulation R146, which is a total of 51 pages, and the then proposed amendment 429, which had a total of 106 pages. So you can see that the number of regulatory requirements has significantly increased from the 429. The draft regulation also has a total of 78 sections compared to the current regulation, which has 56 sections. So the new draft, therefore, has 24 more sections compared to the current regulation, regulation R146. There are finally many changes in terms of also the definitions, with a total of 47 definitions being removed and about 32 new terms being proposed. We will just look at the few critical additions that we think we should note. Also, we think with, of course, my colleagues, that it is more reader-friendly, the draft regulation, compared to the other ones, because it has included tables under each section, and also referencing has really improved from the previous from the current regulation even, also the draft that was never promulgated, Regulation 429. Also, there are annexures. The draft regulation has 4 more new annexures. Annexure 6, which looks at major dietary carbohydrates. Annexure 7, that looks into culinary herbs and spices for ordinary use in food preparations. Annexure 8, which looks into South African nutrient profiling, screening criteria for health and nutritional claims. Annexure 6, which talks to illustrative list of foods that need only a date of manufacture or a date of packaging as appropriate. And then Annexure 10, that talks about front of pack nutrition labeling logos. The draft regulation also has stopped referencing to the South African national standards. Instead, it is referencing a lot to the relevant acts, and also included the definitions to go with the regulations. There are also important changes, key changes that I think are worth going through. The first is the permitted and prohibited claims. The other one is the prohibition of trademarks and trade names. And then the second two, this is what the industry is very much interested in, which is the public health sector, that is the marketing restrictions on unhealthy foods and the front of the pack health warnings. I'm very excited about this because they're of the belief that it will go a long way in addressing unhealthy health habits that are of course causing a strain on our health system. So the public health practitioners are very excited about the inclusion of this, looking at the impact it could have to try to reduce the amount of people who get sick because of the unhealthy habits. So we are yet to see if it will serve that purpose. Then another key change is artificial sweeteners and sugars, and also the role of guidelines. So those are the key changes. Now let's look at the new definitions, but of course we're not going to look at each definition. We're going to just sample at least 3 of them, talk about them, and then we'll urge you to look at all the other definitions to make sure that you understand what each new definition means and how it can impact your food business. The first one is the best quality before date, which has an exact definition as best before date, just with a new addition, which reads as follow, open quote. However, beyond the date, the food may still be acceptable for consumption, close quote. So the long-standing debate around the best before date has been addressed in the new regulation. The definition of best before date has therefore been changed to accommodate the fact that food may still be acceptable for consumption after the best before date, as much as food, of course, can spoil before the best before date. The additive definition has also excluded processing aid, and the regulation 36 has included additional requirements for processing aid, which not then be declared. Then number 3 talks about the front of package labeling, including the ages of children, which the marketing including children 18 years and under. So those are just the key things that we thought we could highlight. And now let's move over to then the specific changes under each regulation. So we will discuss some of the changes, but of course, we are not going to look at each one of them. We are just doing a sampling exercise to show you the most important that we think you should be taking into account. So the first one is sub-regulation 2, which has been slightly updated on wording, but the requirement has remained the same. And then sub-regulation 3, which has been made more explicit regarding who is responsible for ensuring compliance of product labels with these requirements. And that is the person whose business or business name is marketing the foodstuff for sale, who will then be responsible. Then sub-regulation 4 further outlines on the new draft that any information required by the regulation but not included on the product label must be provided immediately upon request, meaning it must be kept in the store where the product is being sold. So that's what it's assumed to mean. Then the rest of the requirements are similar to those in regulation R146 and regulation 2. However, the presentation of the requirements or the wording and order, is different to the R146. But of course, as we said, the regulation has fundamentally remained the same. So that is regulation 2 under general requirements. Now let's go to regulation 3 that talks about presentation. So let's see what is it that has been introduced there. There are a few additions that have been made, which the first being regulation 3.1, which reads as follows: subject to regulation 4, the information that must appear on food labels must be in English, and where label space permits, a second official language of South Africa of the manufacturer's choice, provided the minimum letter size used for the required label information may not be reduced to accommodate various languages or for local or export purposes. So it's important to note that this is meant to clarify that the second optional language can be added on the label, provided it does not affect the visibility of the primary labeling language, which in this case is English. Then section 1B has another addition on the contract of label, of the label, setting that it should be indelible, clearly visible, and easily legible, with a significant contrast between font color and background color, and the legibility thereof must not be affected by pictorial or any other matter, printed or otherwise, provided that colors used on labels shall not dominate or overwhelm, nor be used in such a way that any information, warning statement, or front of pack labels, logos, when applicable, become poorly visible, non-legible, or indistinguishable from pictorial representation and information. And white lettering on any background color except black shall be prohibited. So important to note that the draft regulation has highlighted the need to refrain from using creativity that might hinder consumers from accessing important information about their product. So again, let me just mention that as AEC consultants, we offer various services, which include compliance advisory services. For example, labeling regulation. We do offer training. I think we have got 4 courses that you can do online at your own pace. We also do physical as well as virtual training. So we have got the different choices or options that you can choose depending on what is convenient to you. We also supply document templates ranging from basic food safety templates up to the high-level schemes such as your BRCGS, your FSSC 22000, IFS, Global Gap, and many others. So you can just go to our website to see what we do. We provide maintenance of systems and updating of systems. So if you don't have time and you need somebody to update your system or to regularly maintain it, where we come once a month, twice a month, or once in a quarter, then we also do that. And of course, auditing, primarily supplier, customer, as well as just internal auditing, so that you can get another perspective from a different eye. Now let's move to regulation 6 to see what is it that has been changed there. So regulation 6 speaks to the country of origin. There is, of course, a significant change under regulation 6, where the amendment regulation prohibited the use of national flags. So the new draft regulation permits using national flags when referring only to the country of origin. So there are conditions to that, where regulation 2A of regulation 6 reads as follows: that using a national flag is only permitted to indicate the country of origin when accompanied by the wording contemplated in sub-regulation 1, And in the case where the wording proudly South African is used, the South African flag may be used provided the product complies with the criteria of products or the name of the country and origin. So that is the condition that has been set there. Then Regulation 8 speak to date mark. The best before date, quality date, that has been defined better to suit the industry or to provide more clarification where it permits the sale of foodstuff past their best before, provided that the integrity of the product has been maintained. But this has two exceptions. They must be enhanced foodstuff sold to children. The two exceptions include enhanced foodstuff sold to children, important foodstuff. So the importance of including the date of manufacture has also been highlighted under the draft regulation. And the best before quality date has been added under Section 2, and then the expiry date has been included under Section 6A. So you just must make sure that you pay attention to that. Then let's move to Regulation 9, which talks to prohibited statement. So it reads as follows, that all endorsed foodstuff successfully qualifies with the screening criteria of the nutrient profiling model for South Africa as outlined in Annex 8 using the electronic calculator, which is available, of course, when you go to the website of the Department of Health, although in some cases, people have found that the links were not working and is therefore not required to be any front of pack logo. So please just make sure that for endorsed foodstuffs, you read carefully what that regulation says. Okay, there is also change in the fiber content and sugar percentage in endorsed fruit or vegetable juice. And below it says just in terms of the summary, it reads as follows, that in the case of fruit or vegetable juices being endorsed, the fruit or vegetable juices being endorsed does not contain or should not contain any added sugars or free sugars. They qualify then for the non-addition claim for true sugars and has an intrinsic dietary fiber content per 100 ml that equals at least 20% of the dietary fiber content of 100 grams of the same fruit or vegetable, provided that the dietary fiber is an intrinsic natural fiber from fruit or vegetable pulp, purees, paste, and not added purified non-starch polysaccharides or NSPs. So there have been also new requirements included in terms of wine and alcohol. Subsection 4 covers all these requirements, which I think you should really pay attention to and just look at and see how it affects you. Then Regulation 24, which is the other one that we picked, speaks to bulk stock. Right, so let's look at what it says specifically. So it outlines in terms of this regulation the requirements for foodstuffs that are packed in bulk, and there is additional packaging that covers labels. There is significant addition on the labeling information that must be provided on the bulk packaging above the additional packaging. So that is the name of the product, the name and address of the manufacturer, the special storage conditions, allergen information, batch code, as well as appropriate date marking. There is also an additional requirement for bulk storage of cheese and deli type processed meat, meat loaves, which they are required to have packaging date and repackaging date when sliced or and actually repacked. Regulation 25 talks to small packages which are not exempted from the front of pack labeling. So the Regulation 25 states that the packaging of any pre-packed foodstuff that has a total exterior area of 2,000 square millimeters or less, including single ones-off use 10 grams or less size packages of culinary herbs and spices, sauces, and condiments, and 25 grams or less size confectionery products are exempted from the requirements of labeling. The new draft regulation has also one new addition, including the FOPL logo, if applicable. so not completely exempted, but if applicable. Then let's look at Regulation 27, talks to vending machines. So vending machine products have one crucial additional requirement on the visibility of the front of pack label. Pre-packed foodstuffs which are required to bear a mandatory FOPL shall be packed in the vending machine in such a way that clearly displays the foodstuff, with the main panel on which the FOPL logos are clearly visible from the outside of the machine. So the thinking is that this will ensure that consumers see the warning labels before they purchase the products. Let's then move to Regulation 29 that speaks to pre-packed food additives. The requirement now states that labeling of prepacked food additives must comply with the requirements of the latest edition of the Codex General Standard for Labeling Food Additives. And the requirements state that prepacked additives do not have to include a nutritional table, which of course is a good clarity for the industry. Then Regulation 30 covers flavorants, where in terms of the new requirements, there's just one requirement that under this section for compound flavoring labeling, where it reads as follows: that subject to Regulation 20, mixtures containing one or more flavorings, other ingredients such as salt, sugar, herbs, spices, or other categories of food additives intended for use in or snack foods or in other products must be considered as being compound ingredients and must be labeled accordingly. Okay, then let's look at Regulation 31. Regulation 31 speaks to artificial sweetness. There is a new requirement in the draft which outlines labeling requirements for foodstuff which artificial sweetness of labeling foodstuff with artificial sweetness. So you must just check there if you are using a lot of artificial sweetness to make sure that if you have got any concerns, your comments are taken into account. Regulation 32 speaks to modified starches, processing aids, and carryover of additives. The additional requirements are as follows. The first one is the declaration of processing method of modified starches. The second one is the requirement not to declare preparation utensils. And then lastly, the declaration of additives and preservative used. Regulation 37 covers allergens. This section on the draft has grown significantly with additional requirements that have been introduced. The first is the requirement to declare sulfites when the amount is equal or less than 10 parts per million, and then the list of products derived from allergen under subsection 2 exempted from the allergen labeling requirement. Then there are uncommon allergens, which is covered under Regulation 38, where the additional requirement for declaring products made of or containing a part of lupin has also been included. The following labeling is required when your food contains that is allergenicity, where peanut allergic individuals are at high risk to react to lupin present in this product. So you must include that in terms of allergenicity, peanut allergic individuals are at high risk to react the lupin that is present in the product. So you must just ensure that you comply with that. Let's then move to Regulation 42 that speaks to the nutritional information of facts. So there are, of course, numerous changes here and additions that you will find. And the first one that I think is important for us to note is the exemption for having a nutritional table, which does not, of course, only include the vendors or home industry or the draft regulation, but also includes product listed under Table 1. So you should just check the table there. The exemption only applies if no head claim is made on the product. So just also take note of that. There are also more detailed requirements on the values and the structure of the nutritional table, including the credibility of the information provided. So just make sure that you take note of that. And then Regulation 47 talks to additional requirements relating to the nutritional information table. There are several, of course, several essential requirements that have been included under this section that mainly concern laboratory testing, specifications of nutritional laboratory test methodologies that are being used to determine the nutritional information or quality of food. Then Regulation 50 talks to nutrient profiling made for nutrient and food claim. And here, food businesses will need to consider several crucial additions here. And one of them is products that exceed requirements on key nutrient or have artificial sweeteners that must have front of pack label on the main panel to warn consumers. So also take note of that, please. Let's now move to Regulation 51 that talks to or that discusses profiling model for foodstuff for South Africa for the purpose of front of pack label logo on labels for foodstuff that may not be marketed or advertised to children. So the first thing to note here is that prepacked foodstuff must bear a front of pack label logo if it contains saturated fat, sugar, and sodium. And then the second one, that if it exceeds the nutrient cutoff limit of total sugar, total sodium, and total saturated fatty acids as per requirement under this section. And finally, if it contains artificial sweetness. So please pay attention to that. The requirements for front of pack label are described under Annex 10 of this draft regulation. The logo is required to cover about 25% of the front of pack. More requirements prohibit the use of different tactics to encourage consumers to buy items with front of pack labels, which are listed under requirement of the regulation, like competitions, using celebrities and portraying happy families, and so much more. So if you just go there, you'll see exactly what it entails. And then the last thing to mention is products with front of pack label must show the below warning statement during advertisement. So the first one is, I read, open quote, warning, this product is high in, and then in brackets, you have to write the key nutrients that it is high in, and or it contains artificial sweeteners. And of course, excessive consumption may be detrimental to your health. So that is a statement. I read again. This product is high in, you write the key in nutrient, or contains artificial sweetness. Excessive consumption may be detrimental to your health. So that is the warning statement that you need to include. Then just a summary of Regulation 53 to 58, which are new additions. The Regulation 53, that talks to the use of South African food-based dietary guidelines. Regulation 54 discusses claims on packaged water. Regulation 55 discusses foodstuff containing added purified crystalline fructose or added non-nutritive sweeteners. Regulation 56 talks about fake foodstuffs. Regulation 57 talks about for cosmetic claims. And then a last one, Regulation 58 claims presented through pictures. The rest of the regulation guides nutritional and health claims respectively. The draft outlines specific requirements for prohibited and allowed claims depending on the product you are handling. Ladies and gentlemen, this is the end of this presentation. I do hope that our summary has been quite informative, and would also encourage you to go through the regulation and then scrutinize to see how it will affect your facility or the type of food that you are handling. And if then you need to make some submissions, please feel free to comment and submit your comments if you have got